think it's very key to understand that trusting the court's role for the government to get its way on a particular topic of legislation. Do it for migrants and asylum seekers, you'll give them an appetite for it to do it every time they think they've got something difficult in another area of law. Stress the unconservative constitutional revolutionary nature of what's being done. It breaches the rule of law, not just to the ECHR and European Union law has been talking, but common law remedies available to all. Once you start picking and choosing the menus a la carte, policy by policy, and there's mission creep if government gets the appetite for this kind of thing.
I totally endorse what Adrian said about the rule of law, but in response to a specific question, I don't agree that the individual circumstances provision in the bill is human rights compliant. It may be partially human rights compliant, but it's not completely human rights compliant because it excludes certain issues, including the risk of onward refoulement. And it's trying to confine the question of safety to individual circumstances and exclude what are called generic issues. But I've never done an asylum claim or a protection claim which didn't interweave those two things. So in fact, how that could happen in practice is impossible, in my view, to almost impossible to understand how it would work in practice. So I would say that the exclusions under Section 4 need to be, that wording needs to be reviewed and revised. The background picture in Rwanda about lack of freedom of speech, interference with the judiciary, all of those matters are generic, not able to. Refugees in Rwanda are not allowed to speak about political matters. There is a curb on their free speech, which is written into the government's own material about Rwanda. So there's a lot of material already out there which we can brief on facts, which are quite important, as well as the rule of law points.